Hello and welcome to The Presumption. And here's Jim Griffin. Hi, Jim.
Hey, Sarah. How are you today?
Good. How are you?
Good.
And Matt, our wonderful producer.
Hey, guys.
And my wonderful friend, Elizabeth Kelley. Welcome, Elizabeth, to The Presumption.
Thank you so much for inviting me, Sarah.
Of course. So Elizabeth and I, before I get into who she is, met at NACDL, I think at my very first meeting in San Francisco many, many years ago. She was one of the women who was very welcoming and encouraged me to get on the board and do all these wonderful things. And it's been an organization that I've been a proud member of ever since. So I've always appreciated you. I've always, followed all the great work that you do. And I have to say, Jim, back then I was like, why is this woman doing just this specific niche? I was a new criminal defense lawyer. And I was like, what, like, this is all she does, and of course, once
and
I got once I got into the grind, I was like, yeah, okay. All right. So obviously our podcast part of its mission has been to shed light on mental illness in the criminal justice system. We call it the forgotten disease. And there's really nobody better than you, Elizabeth, to talk to us about your entire career defending those with mental disabilities. And for those of you who don't know, our listeners and viewers, Elizabeth is a criminal defense lawyer with a nationwide practice focused on representing people with mental disabilities. She's the editor of Representing People with Mental Disabilities, a practical guide for criminal defense lawyers, published in 2018, Representing People on the Autism Spectrum, a practical guide for criminal defense lawyers, published in 2020, and then the same sort of idea, but representing people with dementia. And these were all published by the American Bar Association. She serves as the vice chair of the ABA's Criminal Justice Section Council and on the editorial board of Criminal Justice Section magazine. She also co-chaired the Criminal Justice Advisory Panel of the ARC's National Center for Criminal Justice and Disability and the ABA's Commission on Disability Rights, also serving on the advisory board of the Neuroscience Center of Fordham University School of Law. She lectures across the U.S. as well as abroad on representing people with mental disabilities. So I want to turn it over to Jim first, because I just want to sort of, for us to have clarity on the basics, right? Mental illness, mental disability. What exactly are we talking about?
Well,
Jim.
First, Elizabeth, wow, that is certainly an impressive resume, and you have distinguished yourself in this area of the law. And I know you make a distinction between mental illness and mental disability. I'm not sure we all understand what that is and how it plays out in the criminal justice system. So can you educate us on the distinction between
Certainly.
illness
Thank you
and
for
disability?
that question. The question is crucially important, particularly when, as a criminal defense lawyer, I am sitting down with a prosecutor as well as advocating to a court, explaining why my client committed the conduct that he or she is charged with, as well as advocating for the appropriate accommodations within the criminal justice system. Mental disabilities is my global term, which refers to mental illness as well as intellectual and developmental disabilities. Mental illness refers to conditions like bipolar disorder, schizophrenia, major depression, post-traumatic stress disorder. Intellectual and developmental disabilities refers to conditions like autism spectrum disorder, fetal alcohol spectrum disorder, or what we used to call mental retardation. Now, an individual may have one or more diagnoses. So, for instance, an individual with autism spectrum disorder may also have schizophrenia, or an individual with bipolar disorder may also suffer from substance abuse disorder. But nonetheless, it's very important to understand the particular characteristics of each diagnosis and how an individual manifests the symptoms of each individual diagnosis.
But Elizabeth, does drug-induced psychosis, which does exist, does that fall within your realm of expertise?
It falls within my realm of expertise. Its particular significance varies from jurisdiction to jurisdiction.
Mm-hmm.
Because as you said, the long-term effects of drugs may exert a profound impact on an individual, but a court may very well consider that voluntary. And
Right.
as such,
I'm glad Jim brought this up, because I had it in my notes to ask you later on. We just had a case in Ventura County here in California, which is, I don't know if you're familiar, but it's a nightmare of a county to be in. I certainly don't like to pick up cases there. Very, very conservative, very challenging to deal with the prosecution's office there. Anyway, my friend Michael Goldstein, who, Elizabeth, you might know his dad from NACDL. I forget his father's first name, but he and Bob Schwartz were the defense counsel on the case. And this woman was a nurse, or I'm sorry, she was an audiologist at UCLA. She was a doctor. And she was given this weed by her boyfriend, who was it was extremely potent, this weed. Like,
I read about that case. Yes.
Yes. And it came with this warning label and all of this. And she went nuts and she stabbed him, I think, over 100 times or something like that. She stabbed herself over 40 times. She lived, he didn't. A friend of his testified at the trial that he was given the same pot and talked about all the crazy things that happened to him as a result of smoking that weed. So the woman gets, I believe, convicted of involuntary manslaughter and gets probation. And everyone went nuts. Psychosis, my ass. Psychosis, what psychosis? She took it because she wanted to take it. All these arguments that you're talking about, the voluntariness. But I guess it depends, right? If this person is not a pothead, they're smoking something for the first time, it comes with all kinds of warnings. There's a real thing. And when I speak to therapists, they say, look, psychosis is fleeting. You can be in psychosis now and 5 minutes later.
It's a fluid state. It's a fluid state.
Exactly.
And depending upon how the statutes read, it could have very well been that she lacked the intent to commit the conduct. So at that point, you're talking about traditional mens rea arguments. Within the field of mental disabilities, you're typically arguing competency and sanity. And typically, voluntary intoxication is not recognized as an affirmative defense under the major heading of not guilty by reason of insanity. But it varies from jurisdiction to jurisdiction.
Okay. So look, you were just telling Jim about the different types of disabilities and the distinction between disability and mental illness, including individuals who are on the spectrum. Now, I've personally never defended anybody on the spectrum. I've had victims.
Sarah, you probably did, but you may not have recognized it. And people on the spectrum are often very good about masking their symptoms, particularly girls and women.
Well, and they're also functional in many areas of life. They could be
perhaps more functional than we are. Yes.
Yeah.
Highly intelligent.
Exactly. So maybe I did, but let me say, knowingly, I don't think knowingly I've represented anybody on the spectrum, but I've certainly had accusers who, and it was very challenging also in that respect to cross-examine, to interview, all of that. So I want to talk to you a little bit about this. How is it, like, you recently represented a man, this was really interesting to me, named Devlin Thompson, who was sentenced for attacking a police officer during the January 6th riot at the U.S. Capitol. And it seems like the court wasn't swayed by this whole presentation of, his lack of mens rea because he was on the spectrum.
Well, I think it's important to recognize the symbolism, if you will, of the insurrection on the Capitol.
Yeah.
And as I have said to some people, the judge was very thorough in his reading of our sentencing memorandum, and he considered all of the arguments.
Right.
But I think
but
bottom,
didn't he also say this guy's been holding a job at $90,000 a year? So
well, let me get to that. Yeah. But I think at bottom, the judge was profoundly offended by what the march on the Capitol meant. Now, going back, what the judge said in that particular context is very, very typical of what many judges and also prosecutors say. That is to say, if you present to the court your client with a constellation of symptoms, they don't always understand how it can be contradictory. So, for instance, in that particular instance, my client was on the autism spectrum. Indeed, he was diagnosed many years before, and the current evaluations I had of him were very clear cut. But by the same token, this client was indeed functional in some areas. He, for instance, had held a job.
Yeah.
And it was a very responsible job. But some people are unable to square the concept of a developmental disability like autism spectrum disorder, where the client is very intelligent, with the fact that indeed they are impaired in many areas of their life, not the least of which is their social communication, their ability to understand, and their executive functioning. So, for instance, on another level, you can have a client with an intellectual disability, and you can explain to the court all of the ways in which your client has difficulty functioning, but then the court points to the fact that, well, he graduated from high school. What you then have to explain is that he went to school during the era when one was basically given a courtesy diploma and was in special education courses all the way through high school. So it's the diagnoses are often fraught with different nuances, and different facts in a client's life may be contradictory to a mental disability. That's one of the reasons why it's very important during the course of a forensic evaluation for the expert to interview family, friends, neighbors, co-workers to amass that long-standing social history to explain how they've always been like this. No, they are not manufacturing this diagnosis for purpose of litigation, and also to reach back and get school records, treatment records, hospitalization records, military records, what have you.
What
Go ahead.
percentage of the clients that you represent who say have a mental disability have been undiagnosed until they encounter the criminal justice system, and then then you're called in?
It's a healthy percentage for a couple of reasons. First of all, if they are older, and excuse me, by older I mean 40 onward, they may have gone to school.
That means we're old, Matt's not, basically. Basically,
they may have gone to school when educators as well as their families were not conversant in different kinds of mental disabilities, and simply dismissed certain behaviors as being odd or abnormal, or he'll grow out of it, or she'll change. Beyond that, even in families where the accused is in their, say, 20s or so, and their family is relatively well educated, it could have been that for years they have known that their now adult child was different, but they were unable to get an accurate diagnosis. And accordingly, they were unable to obtain for their now adult child the appropriate accommodations that would have made it easier to manage the symptoms of that diagnosis.
It's interesting because when you think back to, like my parents' generation, it's very different today, thankfully. When I have a cousin who is severely OCD, he's probably close to 60 years old now. He won't even leave the house. But when he was a kid, I remember him turning the light switch on and off like a million times and wanting a certain
people just dismiss that as being odd.
Being cute. Yeah. And he wanted like certain number of kisses in specific part of his cheek from his mother before going to bed. And it was like, oh, how cute. My son is, so loving. Well, it wasn't cute. It was OCD. And it got so bad that, it's literally is handicapped him. Can't hold a job, can't leave the house. But now, thankfully, I think we're, like you said, we're educated enough and more open to treatment than I think other generations were. So I want Jim to dig into dementia with you, because I think that's so fascinating. And the idea of
Can I ask a quick question before Jim does that?
Yeah.
I'm just curious. It sounds like part of this process is having to essentially prove that these symptoms are not manufactured. And my question is, what percentage of it is manufactured? It seems to me like a TV stereotype, but you can't possibly have clients that are lying about this. So why is that even a question for people?
I would say that probably during the course of my career, I had one individual who, and I don't want to say was faking it, but he was probably exaggerating his symptoms. That being said, the vast majority of my clients, 99%, have a diagnosable mental disability, and there is a nexus between their disability and the conduct of which they are charged. But for people who don't have experience with mental disabilities, they could be cynical about the diagnosis. And also, if they are a victim or if a family member is a victim, they could very well be inclined to dismiss it as a charge or diagnosis conveniently manufactured for purpose of litigation. You may have heard or even remember the case of John Hinckley, who attempted to assassinate President Reagan. And he was found not guilty by reason of insanity. And that started to perpetuate the myth that defendants were getting off all over the case, all over the place, by claiming not guilty by reason of insanity. And in addition, many insanity statutes were made more rigorous in order that fewer people would be able to meet that very, very high legal burden.
Sure. Well, let's talk briefly about dementia. And it was not one of my cases, but it was, someone who I knew and respected growing up. He held positions of authority in our community, and as he got older, he was at the YMCA, and he was in the pool, and there was a kid that bumped into him, and he's, this elderly man just started beating on the kid for, no reason. He gets arrested for assault, and, everyone is just shocked. And, it turns out, he had some dementia going on that, frankly, he had not been diagnosed before. How often do you see that?
I have seen it. I continue to see it, and we are going to be seeing more of it because Jim and Sara and Matt, as the population lives longer, that population is going to have more physical infirmities as well as cognitive infirmities. And dementia is part of that. So Jim, that formerly well-behaved, respected gentleman, lost his inhibitions, lost his filters, and committed an offense which during his prime he never would have committed. Exactly. And one of the challenges we have is to figure out how to accommodate this population within the criminal justice system. First of all, the standard definition of incompetent of competent to proceed doesn't necessarily apply, because if someone is found incompetent to proceed, then the court will order a period of restoration. There's no way an individual who has dementia will ever be restored. The metaphor I use with families is once they fall off the cliff, they will never be brought back. The best that can be done is to manage those symptoms and to understand that in the coming weeks and months and years, those symptoms are only going to intensify. Beyond that, our jails and our prisons are not equipped to treat and to house individuals with dementia. They require intense medical attention, and also they can be very disruptive. And our prison institutions are built on order and strict codes of conduct, which people with dementia simply cannot abide by.
Mm-hmm. We had Peter Eliasberg of the ACLU as a guest not too long ago, and he was talking about our conditions here in LA and the jails here, and how we treat mental. I mean, we just don't have programs. They need programs. They need care. And what they do is they basically
need medication, the proper medication,
proper medication, not some basic whatever, minimum standard, substandard, whatever it is that they give them. And then they chain them to the bench and they leave them there because they just don't know where to put them. So it's
I mean, it's dehumanizing.
Yeah.
But beyond that, if someone has a mental illness or any kind of mental disability, a custodial environment is only going to traumatize them. And most of these individuals will one day be back in our neighborhoods, in our communities. And if they were damaged individuals going in, we do not want them to be even more damaged individuals when they emerge, not only from a humanitarian standpoint, but also from the standpoint of they could commit additional crimes if they are not appropriately, if they are not humanely dealt with by the criminal justice system.
Right. I think Sara was going to ask you about
jails and prisons were never intended to be therapeutic environments.
What'd you say, Jim?
I think you're about to ask her about not guilty by reason of insanity.
Oh yeah, I'm very curious. And I mean, you kind of touched on how that they've made it less possible or more restrictive for people to claim NGI based on mental disability or mental illness. But can you give us an example of where a mental illness or mental disability in a case that you've been involved in has led to NGI, or at least was partially successful in that quest?
Well, first of all, a good NGRI case is very, very rare. That being said, the most successful, or if you will, the most promising cases are those where a doctor, either a psychologist or a psychiatrist, gets into the jail and interviews the person as soon as possible after the alleged crime, when that person is probably still floridly psychotic, and before any medications that the jail is giving that person take effect. And some conditions are more inclined to produce successful instances of NGRI, like bipolar disorder, schizophrenia, schizoaffective disorder. You mentioned earlier a relative who had OCD.
Yeah.
Very, very rarely is an individual with OCD able to mount a successful NGRI defense. But the conditions where psychosis is prominent usually hold the most promise.
Yeah, I mean, early in my career, I remember I had a guy, it was a court-appointed case to me. He was on a bus and he stabbed the bus driver, but he went into the psychosis and he thought that he's being attacked, you know? And I mean, that was it wasn't an NC. Yeah, go ahead.
And some of those delusions come because of the fact that they suffer from PTSD.
Right. I mean, they are fleeting, right? At times. I mean, you could have what you're talking about. You could go into just a rage of PTSD, for example, and then shake out of it and be lucid after the fact. I suspect. I don't.
No, you're absolutely right about that. It's a fluid state.
Right, and it makes it all that more challenging. Now, I mean, we talked about not guilty by reason of insanity, and our listeners may not know exactly what the legal definition is. Can you sort of give us a layperson's rendition of what it means to be not guilty by reason?
Well, there are over 50 different definitions of NGRI, or NGI, as you say in California.
Wait, Jim's in South Carolina, though.
And we're all somewhat insane here, so let's.
But every jurisdiction has its own definition of not guilty by reason of insanity, and the challenge is that the mental health expert, based on their thorough evaluation of an individual. By thorough, I mean interview with the accused, his or her family, friends, neighbors, review of records, has to fit all of that into a very narrow and confining legal definition.
And whatever that is, people always ask me, well, what about competency? How do you distinguish it? Whatever that is, that pertains to the time the crime was committed.
Yeah, exactly.
Now it's ability to stand trial.
Yeah, competency and sanity are very, very different inquiries. Competency assesses a person's present ability to proceed with their legal case. And the accused must be competent at all stage of the proceedings, whether it is during the initial charging, through pretrial proceedings, through trial, through imposition of sentence, even as perverse as it sounds, at the time of execution. And it's an attorney's responsibility to continually assess competent to proceed. Competent to proceed, it basically has one definition nationwide, and that's that an individual understand the nature of the proceedings and have the present ability to assist counsel with his or her defense.
Mm-hmm.
That, as the way it plays out, is a very, very low standard to meet within the legal system. On the other hand, not guilty by reason of insanity is a very high standard. And it goes back to assess one's ability to understand and function at the time the crime was committed. Mm-hmm. And that's one of the reasons why I said earlier that for an NGRI defense to be successful, it is vitally important that the mental health expert meet as soon as possible, observe as soon as possible after the crime, the individual's conduct.
I want to switch gears now and talk about something you mentioned earlier, voluntary intoxication, voluntary drug use, but we all know that, a lot of people with mental illness, bipolar disorder, for example, and, they don't have health insurance, they don't have medications to treat it, and they self-medicate with street drugs and they get hooked on them. And so, how do you persuade judges and or prosecutors that the defendant's drug use is not, completely voluntary? It's it's self-medicating a mental illness, for example. Is that a challenge? Is that something you're able to do?
It is a challenge because, of course, drug use is illegal, except in certain jurisdictions. But it's also important to explain to the court that with many individuals, it's difficult to understand where the mental illness ends and the substance use disorder begins. Indeed, they are interrelated and both must be treated.
Right. Well, that's why we have dual diagnosis facilities now. There used to be a time where we would throw people in a treatment center for alcohol, for alcoholics, right? And we had no distinction.
And it wouldn't work.
Yeah, and it didn't work. And they would come out, they would go right back to the substance again, and we would leave the underlying issue completely untreated. One of the interesting things, I had a young woman who had bipolar disorder and was a meth user. And to Jim's point, it's exactly what she was doing. She hated the medication that she was supposed to take. She refused to take it. Her mother couldn't, force her to take it. And then she was using meth, had a drug dealer boyfriend. So it was easy for her to get it. And I had to jump through some loops to convince the court by way of, first I had her medical records from Kaiser showing that she's actually supposed to take this medication for bipolar disorder, that is her diagnosis. And then because she never had substance abuse treatment, then I had to, put somebody in place to sort of counsel her and then get her into a treatment center. So it was like two different tracks, but there's no way that a court could look at someone like that and say she's making it up. I mean, it was clear she was,
and beyond that,
yeah,
there are often profound side effects with different medications. Yeah. Whether it dulls their ability to think and be creative, weight gain, which in itself is unhealthy, different kinds of ticking, falling asleep, so that can't be denied.
So tell us, Elizabeth, because Jim and I, obviously we have some mental health component in almost all of our cases. Once we get to know the client, their history, even if they're not completely, that they don't have a mental illness, there's some sort of emotional issue and developmental issue that we try to focus on in their defense. And so for you, being that, the focus of your practice is this, how do you tackle a case? So what is, this is a compound question. What does the evaluation process look like? Do you have a team of experts in place? Do you start with a evaluation by a particular expert and then go from there, create a roadmap? Or, how do you take a deep dive to get started?
You raised 1,000 different questions.
Objection.
First of all, it depends upon how the client comes to me.
Right.
Typically, quite frankly, it's the parents. And let's say the parent has been very involved in their adult child's life and is very savvy as to the diagnosis, the way their adult child manifests the symptoms of the diagnosis, can list the various treatment providers, any facilities, attempts at accommodations, etc. Based on the diagnosis, I then will suggest a qualified mental health expert or team of experts. So for instance, in the case of someone with autism spectrum disorder, that is a very specialized field, and I have a few go-to experts. Mm-hmm. I also know that a good expert will will stay in his or her lane. So for instance, that expert may only want to do a diagnostic report. Mm-hmm. And I may need to bring in a special expert to give an opinion as to future dangerousness. Mm-hmm. Because no matter how compelling a diagnostic report may be, mm-hmm. a logical question which a prosecutor or ultimately a court may ask will be, okay, I get it. She has this disorder. He has this disorder. Mm-hmm. But will he or she commit this crime again? And what are you going to do to ensure that that does not take place? Mm-hmm. If, for instance, an individual comes to me and that individual has a brain injury, mm-hmm. or some other brain disorder, then I will more likely than not recommend a neuropsychologist or a neuropsychiatrist. For instance, I recently had a case where the young man had schizoencephaly, which basically means he only had a portion of a brain. Mm. And his parents were very, very good about giving me a list of all of the prior treatment providers, as well as providing a detailed narrative of what their child was like on a daily basis. Mm-hmm. And I brought in a superb neuropsychologist who drew a very, very clear line between my client's diagnosis and the conduct with which he was charged. And this was.
Am I correct that there are two things that you have to accomplish that are most important: is drawing that nexus between the offense conduct and the mental illness or disability, and also satisfying the court and the government that treatment will deter future criminal conduct, right? I mean, you got to accomplish both things, right?
Exactly. And tied into that latter point, right. In the case of someone with mental disabilities, mm-hmm. paint the path forward for the court. Not only that if the client is released, he or she will get the appropriate treatment and accommodations, but also prison would be counterproductive. Indeed, in some instances, it could be fatal.
Yeah, and that leads to the next topic. You know, are courts and the judicial system, have they caught up with the issues addressing, the mental disabilities and mental illnesses? And, as, in the, I guess, adjudicating them guilt versus innocent, that's pretty easy. It's pretty almost impossible to get not guilty by reason of insanity. But point you just touched on is, what do you do with them once they're in the court and they plead guilty? I mean, you send them to prison, they get worse, but there's not many resources in a lot of poor states in the South, and the in between the coast of the United States. So we don't have resources here in South Carolina to do that. I promise you.
No, your point is very well taken. There is a huge shortage of appropriate facilities, whether you are in Anchorage, Alaska, or Midtown Manhattan. That being said, in terms of your first question, how conversant are courts about mental disabilities? It's not so much how conversant they are, but how willing are they to learn? And I have had the privilege of being in front of some judges who were very, very eager to learn. And based on that knowledge, that newfound knowledge of a mental disability and how that disability manifests itself within my client, the court was happy to make an accommodation. But there is a severe shortage of secure facilities and treatment facilities, as well as community-based treatment within this country. And the challenge that any criminal defense lawyer has when advocating for a non-prison sentence is to put together a roadmap showing 24/7 exactly what a client is going to do, and perhaps explain to the court that because of the geographic area where they live, there's not a perfect facility, but these are the different kind of resources that the family and counsel have tried to weave together.
So before we sign off, you mentioned to me off the record some recent cases you're involved in with brain injury and brain development issues, one in Indiana, one in California. In one of them, the defendant was facing 40 years and got probation, which is pretty damn amazing. The other one, he was facing life, and he's going to be out in like 8 years. So what led to those results? And this is specifically interesting because it's not a disability, it's a injury, right? Brain injury.
Well, in the case of the young man facing life, the key phrase there is young man. We know, the science tells us, that the brain is still developing into the 20s. One may be deemed an adult at the age of 18 in the eyes of the law. But someone in their early 20s is still functioning as an adolescent. They don't have a sense of consequences. They're still tremendously susceptible to peer pressure, and they don't have the ability to evaluate consequences like a fully formed adult would be. So in this case, I basically worked on the mitigation, and we were able to put together a really rich social history saying that until this hugely unfortunate accident, this person, although he had been in trouble before, didn't receive the appropriate resources, that indeed the juvenile system was more harmful than it was helpful. And now as a young man, he still hadn't acquired the tools that he needed to function as an adult. And that's why he committed the crime in question. In terms of the other individual who had schizoencephaly, which basically means a portion of a brain, and who suffered a head injury, I described this a bit earlier on. We had a superb neuropsychologist who drew a line between this young man's brain and the conduct charge. And we also had another superb psychologist who talked about this person's cultural background and his early childhood and the trauma that exerted on him, and how as a young person he had never really learned how to sort through that trauma and how to deal with his issues of anger.
What's that condition called? I feel like I have that today.
Schizoencephaly. Encephaly. But
okay.
It basically means, literally translated, a split brain. It sounds a lot like schizophrenia, but it's not schizophrenia, and it certainly isn't a mental illness.
Right.
It's an intellectual disability.
But before we close, Elizabeth, I want to share an experience with you. During COVID, when coming out of COVID, there's a huge backlog of criminal cases. And I had a friend of mine who's the DA in the area. We call them solicitors. And he asked me to volunteer to try to clean up their backlog in a small county in the state. And I agreed to do so. And there's one case that I was the prosecutor, but the defendant had burned his dad's trailer down that his dad let him live on behind his dad's house. The kid had all sorts of mental problems, and it was, and his dad had taken him in, but the kid, I don't know what his diagnosis was, but, the dad we all knew that jail was not the place for him, because he was shitting on himself every day in the jail. And the jail was saying, you got to get him out of here. You got to get him out of here. And there's no place to send him. And that kid, he had there was an opportunity, I'm sure, as a younger child to get the treatment and help, the tools that he needed. And, by now he's 30 years old. And we're all just stuck. And I left that position. It was short term and still hadn't figured out what to do with it. No one, jail wasn't the answer, but there was no facility for him.
There's no resources we're like honestly, I think we're like the worst country when it comes to, mental health and the mental health of our homeless and just the lack of social workers. It's definitely not something.
And even in the case where the individual comes from an intact family, think about the burden on that family. The parents are going to get older. And what's going to happen to that individual?
Yeah.
And while that individual was growing up, his or her presence had a huge impact on the siblings. Yeah. And they may very well have made sacrifices to accommodate their sister or their brother. So,
it's a challenge. And this has been very helpful, Elizabeth. Thank you for coming on.
Well, thank you for the invitation.
Who are you going to call? Elizabeth Kelley.
I appreciate your spotlighting this issue.
Of course, my God. And I rarely go on LinkedIn, but I was on LinkedIn. I think my assistant updated my thing. So I was just looking at it to see if it's okay. And you popped up with this article in the ABA Journal. And I was like, oh my God, we got to talk about this. This is an important
I'm glad you did.
Yeah. Thank you so much for joining us. And for our listeners and viewers, until next time, Jim.
Well, Matt's going to remind us where we
can. Sorry.
That's all right. I just wanted to let people know if this is your first time listening to the podcast, maybe you've joined because Elizabeth is our guest. We've got tons of other great episodes to listen to. We're available on all the podcast platforms at The Presumption. You can also check out the YouTube version where you can see Sara popping in and out of this entire conversation. That's at youtube.com/@thepresumption. And that's also our social media handles at The Presumption on Twitter, Instagram, all that good stuff. And thank you all so much for listening. And now, go ahead, Jim and Sara.
Yeah, Sara.
Until next week, we rest.
We rest.